I've got you under a contempt warning as well. And if you continue to say you don't understand when you clearly understand, then I will hold you in contempt for that as well. Do you speak English?
I don't understand how you can force.
You answer my questions.
How you can enforce.
Sir, you answer my questions before I let you talk again. Do you speak English?
I speak Moorish American.
Okay, sir. Whatever that is. All right, Mr. Pugh, we'll see you back next Friday at 9 a.m. We're adjourned.
Thank you, appreciate
another contempt warning. If you talk over me another time, I'm going to find you in contempt and I'm going to sentence you to up to 6 months in jail. You understand that?
No, I do not.
You understand that?
No, I do not.
Do you speak English?
I speak Moorish American.
Thank you. Prince Pugh, state what you please set a record.
Yes, Your Honor. Thank you. This is State of Indiana versus Prince Pugh. Cause number is 64D01-2305S64448. Defendant appears in court in person by video conferencing with counsel, Mr. Steve Pribble. State of Indiana by Gary Gurman.
Morning, Mr. Pugh. Can you hear us okay?
Yes, now comes the respondent, Prince Pugh Bay, a national state citizen to the United States of the American Republic, a sovereign government that has its own jurisdiction.
Mr. Pugh, you keep filing things with the court, and you can't file things with the court because you have a lawyer. We don't.
I object. I object to any counsel on my behalf.
We don't permit hybrid representation. You have a lawyer that's been appointed for you. Anything
I object to any counsel.
If you keep talking over me, I'm going to hold you in contempt. Do you understand me?
No, I do not.
What don't you understand?
That I object to any counsel and that you're denying me representation pro se.
You've never requested to represent yourself, sir.
Since day one, I represented myself pro se with all my filings.
You have never once requested affirmatively to represent yourself. You've
since
never
day one on the record
to represent yourself, sir.
Yes, since day one.
Not a single time. I'm telling you right now.
Since day one, I fired the attorney. I have it.
If you want to make a proper motion to represent yourself, you need to do that, but you have not done so, sir.
I have filed it. Did you go over my documents?
I see the documents that you file, and because none of them ever asks for your ability to represent yourself, I strike everything from the record because you have counsel and we don't permit hybrid representation. It's that easy.
Do you have a written order of those strikes so I can appeal?
Your Honor, may I interject for just a minute, please?
Go ahead, sir.
On June 12th, Your Honor, I did file a motion for leave to withdraw. In that motion, I did attach an affidavit from my meeting with Mr. Pugh. In that affidavit, he does specifically and clearly state it is his desire to represent himself pro se. He acknowledged his constitutional rights. He acknowledged his FREDA warnings, but he did make that request, Your Honor.
He made that request in an affidavit in your motion to withdraw.
That's correct.
Okay, he needs to make an affirmative request of his own directly to the court that he would like to represent himself. Upon so doing, I will hold a FREDA hearing like I do every other time. Until that happens, I'm not going to hold a FREDA hearing.
I object.
Sir, you can object all you want. That is my ruling.
Well, I object.
If you want to ask for the ability to represent yourself, you need to do so affirmatively. If you want to do that right now, I will listen. That's all
I object. He just stated to you that I specifically and clearly motioned to represent myself since day one.
Well, then
he just said that on the record.
You have not, sir. You have not.
The court has yet to identify its status of jurisdiction.
Sir, that is absolute nonsense. I don't even know what you said. All right?
I said the court has yet to identify the status of jurisdiction.
Yourself, you have to make.
If you clear the bias out your ears and out your eyes, then you can hear what I'm saying. The court has yet to identify the status and legal jurisdiction. I'm a Moorish American national through the United States of American Republic. i.e. a Native American.
Or you wouldn't be sitting there in jail right now.
I'm a Native American. It's called due process. This is a gross due process violation constitutional violation as well as civil rights violation.
Mr.
A
Pugh,
judge cannot sit in
exactly what
authority
needs to happen.
over a
Keep
foreign state
talking over
citizen.
me. This is another contempt warning. If you talk over me another time, I'm going to find you in contempt and I'm going to sentence you to up to 6 months in jail. You understand that?
No, I do not.
What don't you understand?
I don't understand how I'm representing myself and you're cutting me off on the record for stating
You are
for
not
stating
representing
on my
yourself.
behalf.
You have appointed counsel, sir.
I object to any appointed counsel.
On May 25th, 2023, you sat before me and requested the appointment of counsel.
I object.
I appointed counsel based upon your request. Since
I
that time,
object.
you have not affirmatively requested to represent yourself before this court. If you want to do so, I will hold a Ferretta hearing. If you do not do that, I will not hold a Ferretta hearing, and Mr. Pribble will carry on as your attorney. Do you understand?
No, I do not.
All right, sir. Then this case is adjourned. I will see you back next Friday, and we'll continue to have hearings every Friday. I've got
Yes.
you under a contempt warning as well. And if you continue to say you don't understand when you clearly understand, then I will hold you in contempt for that as well. Do you speak English?
I don't understand
Do you
how
speak
you can
English,
force
sir? You answer my questions.
how you can enforce.
Sir, you answer my questions before I let you talk again. Do you speak English?
I speak Moorish American.
Okay, sir. Whatever that is. All right, Mr. Pugh, we'll see you back next Friday at 9 a.m. We're adjourned.
Thank you, Fish. Appreciate you.
Rachel Arms. Let's go with Joe Morrison.
Judge, I can set the record.
In the end, the hearing resolved very little about the underlying criminal case, but it made one thing unmistakably clear. The judge maintained that Prince Pugh still had appointed counsel because he had not made the clear, affirmative request required to trigger a Ferretta hearing, despite repeatedly insisting he had been representing himself since day one. Throughout the proceeding, the court stayed focused on procedure, while Pugh continued raising jurisdictional challenges, constitutional claims, and objections to appointed counsel. Those arguments never persuaded the judge to change course, and instead the hearing ended with another continuance, multiple contempt warnings still hanging over the defendant, and the invitation to properly request self-representation remaining on the table. Whether you believe the judge strictly enforced courtroom procedure or think Pugh's concerns deserved a different response, this hearing shows how quickly a case can become consumed by process instead of substance. What do you think? Was the judge simply following the law, or should the court have handled the self-representation issue differently? If you found this courtroom showdown as fascinating as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and legal analysis.